Imagine this. There's a family divided by court orders that have been in place for several years. The mother has full parental responsibility, and the other parent is granted visits for 7 hours per week. No overnights, no calls, no holidays. The children, they're almost 14 and 15 now. Their relationship with their other parent is strained. Week after week, they're forced to visit their other parent. They've expressed a desire not to be compelled to do so. But when can they decide whether or not they want to go for these visits? The older one, nearly 15 now, expresses frustration and anger about the situation. He's even suggested taking legal action against his father. This is a common sentiment among children caught in the crossfire of custody battles. They often feel unheard, their emotions swept under the legal rug. They grapple with feelings of helplessness, resentment, and confusion. Our 15-year-old, for instance, may not fully understand the nuances of the law, but he knows he's unhappy. He knows he doesn't want to be compelled to meet his father. He knows he wants a say in the matter, and he's not alone. Many children in similar situations yearn for a voice, a chance to express their feelings and preferences. In the world of family law, there's no specific age at which a child can refuse to comply with a court-ordered visitation schedule. But the court will take into consideration the child's maturity and understanding of the situation when considering their views. This was seen in various cases where the courts had to weigh between maintaining meaningful relationships with both parents and protecting children from any harm or distress. Let's delve into some real-life case studies that illustrate the complexities of child custody decisions, particularly when the child's wishes conflict with court orders. Imagine a case where a 12-year-old girl, let's call her Sarah, was compelled to spend every other weekend with her father. Sarah expressed her discomfort and fear to her mother, but the court order was still in place. The court had to consider Sarah's distress against the importance of her relationship with her father. In another case, a boy named Alex, who was almost 15, was required to visit his father, whom he hadn't seen in 5 years. Alex was adamant about not wanting to see his father. The court had to consider Alex's age, maturity, and his clear expression of his preference. In both these cases, the court had a difficult decision to make. On one hand, maintaining a relationship with both parents is generally considered in the child's best interest. On the other hand, forcing a child into a situation they find distressing can have a detrimental impact on their emotional well-being. These are just 2 examples. There are countless others. Each case is unique, but they all share a common thread. The court's primary concern is always the child's best interest. This can sometimes mean weighing a child's expressed wishes against other factors, such as the potential benefit of maintaining a relationship with both parents. In these situations, it's crucial to have a skilled family law attorney who can effectively advocate for the child's wishes and best interests. These professionals can help navigate the complexities of family law and argue for modifications to existing orders when necessary. Remember, if it can be demonstrated that enforcing visitation against the children's wishes is causing emotional distress and negatively impacting their well-being, then it may be possible to argue for modification of the existing order. The court has discretion to vary an order if it is satisfied that there has been a significant change in circumstances since the order was made. This is a key point we've discussed today. There isn't a magic age when children can outright refuse to follow court-ordered visitation. However, their views may carry weight when they reach an age of maturity and understanding. We've seen this in the real-life cases we've explored. In family law, the child's best interests are always paramount. This principle is the cornerstone of every decision made, from visitation rights to custody arrangements. Courts strive to balance the need for children to have meaningful relationships with both parents against their need to be shielded from harm or distress. Remember, a child expressing strong feelings against visitation may indicate a need for modification of the existing order. If the court can see that enforcing visitation against their wishes is causing emotional distress and negatively impacting their well-being, a case for modification could be made. However, it's important to understand that each case is unique. There are no one-size-fits-all solutions, and the court considers various factors including the child's maturity, understanding, and emotional state among others. However, clarifying conflicting information on child's autonomy in visitation decisions as per family law provisions can be complex. The child's feelings and preferences will be considered by the court alongside other factors in determining what is in their best interests. And that's where we leave this discussion. But remember, it's essential to consult with a legal professional to navigate these complex issues. So let's delve deeper into the child's perspective. It's important to remember that custody battles and court-ordered visitation can take an emotional toll on a child. They may feel caught in the middle of their parents' conflict, leading to feelings of guilt, stress, and anxiety. Professional help and support for children in these situations are crucial. Therapists and counselors can provide a safe space for children to express their feelings and learn coping mechanisms. They can also help children understand that they are not responsible for their parents' issues, which is a common misconception among young children in these situations. Furthermore, child psychologists play a significant role in court proceedings. They can provide expert testimony on the child's emotional state and the potential impact of various custody and visitation arrangements. They can also help the court understand the child's perspective, ensuring the child's best interests are always at the forefront of any decision. Understanding the child's perspective and emotional state can help in making informed decisions. Remember, the goal is to ensure the child's well-being above all else. In our next scene, we'll look at how to apply this knowledge in real-life scenarios. Let's wrap this up. Child custody and court-ordered visitation is a multifaceted issue, and it's crucial to remember that every child and situation is unique. The child's wishes and emotional well-being should always be at the forefront of any decision. The court plays a vital role in safeguarding the child's best interests. It considers all aspects, including the child's emotional state, the parent's ability to provide a stable environment, and the child's wishes, if they are mature enough to express them. Moreover, it's important to note that custody orders are not set in stone. They can be modified based on changing circumstances, such as a change in the child's needs, a parent's living situation, or even the child's preference as they grow older. Professional support, like therapists and child psychologists, can greatly assist in navigating these changes and ensuring the child's emotional health is maintained throughout. In conclusion, remember that the child's well-being is always the top priority. It's not about winning or losing in court, but about ensuring the child has a safe, stable, and loving environment to grow and thrive. As we move forward, always keep this in mind. In our next scene, we'll be concluding our discussion.